It was with such pleasure that I accepted the invitation to come and chair this evening's event on behalf of the Bingham Centre. And as you know, and Lady Bingham is here tonight and members of the family. I see Jessie, I see Kate, I see Kit, and I see Lady Bingham herself, and I see grandchildren too. And it's really a special occasion because, of course, Tom Bingham was such a hero of us all, and such a great lawyer and judge. And his book on the rule of law is one that is carried, I hope, by all of us. But tonight, Richard is the person who's going to turn his hand to that subject of the rule of law. And I want to just start by paying tribute to him. We've just had the newspapers full of the 100 days of a new government. And I have to tell you that for me, one of the best of the outcomes of that 100 days was the appointment of Richard Hermer to be the Attorney General. But we actually got an incredible team of lawyers. And we have with us Sarah Sackman, who is the Solicitor General, and again, a wonderful appointment, and Shabana Mahmood is the Lord Chancellor and Minister of Justice. And that triumvirate is really a wonderful team of lawyers to be the law officers in the new administration. Now, Richard will be known to many of you, but not to all. And I know him because he was a member of Doughty Street Chambers. He was called to the bar in 1993. He's a son of Wales, and he studied at Manchester. And he came to the bar in 1993, and he came straight to Doughty Street. And there he was until he became a Queen's Counsel in 2009. Only 16 years of practice, but he was a stellar lawyer, and his practice already was of such richness and significance, and his skills as a lawyer so clear that he was appointed Queen's Counsel when still very young. He moved to Matrix Chambers in 2012 and was appointed a Deputy High Court Judge in 2019. In his years of practice, he has roamed wide, but I would say that it's been clear always that he has been a champion of the rule of law, of justice. And I had the great pleasure of being present when he took his oath of office. And when he made his speech before our Lord Chief Justice, our Lady Chief Justice, Sukkar, when he made his speech, he spoke about the importance of legal analysis always guiding him, that his legal analysis would be guided by law and not by politics. But he is a man who did study politics before he studied law, it has to be said. But he also said those important words, which I think all of us cherish, which is about the role of law officers speaking truth to power. And I think that we will hear something of that tonight. Many cases have gone through this man's hands. There was grief in certain legal practices, law firms who had briefed him for cases that were where he had to make it clear that he wasn't going to be available. They all assumed that you were going on to the High Court bench. You know that, because he said it was a matter that couldn't be disclosed. And so the assumption was, oh, he's gone off to be a judge. Well, he's gone off to be the Attorney General, and I know that he will give us a great comfort in the words you're about to hear as to his guiding principles in that role. Thank you.
Good evening, everyone, and thank you, Helena, for that introduction. It's a real privilege, Helena, to be introduced by a friend who I admire and respect so much, and indeed by someone who has spent a lifetime promoting the rule of law and protecting human rights. Can I also thank the Bingham Centre for inviting me to speak to you all this evening. For nearly 15 years now, the Bingham Centre has been the essential voice for the advancement of the rule of law values at home and also abroad. Its work to promote a better understanding of the rule of law and to help build capacity to give it practical effect has never been more vital than today. It's a record of which Tom Bingham, in whose name I am honoured to give this lecture, would surely have been proud. And it is wonderful to see so many of his family here tonight. Lady Bingham, Dame Kate, Kit and Mary. Lord Bingham's judicial and non-judicial writing, his stature as one of the great post-war judges, has been an inspiration for generations of lawyers, myself very much included. I had the privilege of appearing in front of Lord Bingham as a junior in a series of interesting cases before the House of Lords, in which I was led by a promising young silk called Keir Starmer. But like many in this audience, I also felt a personal tie to Tom Bingham. I applied for silk in 2009, and Lord Bingham was one of my referees. But sadly, my father, who was a lawyer, died shortly before news of my appointment. My sense of loss at not being able to share the news with my dad was softened by the fact that before I died, I was able to show him a letter that Lord Bingham had written to me. The letter was filled with the warmth and support that many who knew Tom Bingham would recognise. Thus, I will always feel a very personal debt of gratitude to him for the joy and pride that his letter gave my dad. It was in his cogent and elegant account of the rule of law that Tom Bingham encapsulated his 8 principles. Such was the authority and clarity of his analysis that the principles are now a necessary reference point for any discussion, indeed speech, on the subject. As Sir Geoffrey Jowl put it when he spoke at the launch of this centre back in 2010, tear open the Bingham package of requirements for the rule of law, and as each of its ingredients falls away, we progressively observe the stark outlines of tyranny at worst, or authoritarianism at best. Sir Geoffrey's remark has a particular resonance today. And what better illustration of the enduring contribution of the book than can be the sight earlier this year of its Ukrainian translation being launched in Kyiv, on the front line of the ongoing struggle for democratic, rules-based values. As that scene attests, we are living through uncertain and challenging times, with threats to the rule of law on a number of fronts. And this evening, I would like to talk about the necessary response to these challenges through restoration of our reputation as a country that upholds the rule of law at every turn, and by embedding resilience to rebuff the populist challenge. Restoration and resilience. And I'm going to begin by setting out the nature of the challenge as I see it, as well as proffering some thoughts on the relationship between the rule of law, democracy, and human rights. I'll then turn to 3 themes that I consider lie at the heart of the restoration and resilience project. Firstly, the rebuilding of our reputation as a leader in the field of international law and the international rules-based order. Secondly, the strengthening of Parliament's role in upholding the rule of law. And thirdly, and vitally to my mind, the promotion of a rule of law culture. The starting point is not a happy one. Conflict currently affects more countries than at any time since the Second World War. As too many people around the world are driven from their homes by wars and instability, there is a sense, a palpable sense, of an international system that is unable to act, that is unable to prevent wars and aggression, and is unable to address desperate humanitarian need. As the Prime Minister said at the General Assembly in New York, those institutions of peace that the United Kingdom and others worked so hard to establish after the horrors of the Second World War are struggling. Those rules we have all worked so hard to maintain are being undermined. And faith in international law and the international rule of law is being chiseled away in communities who are told time and time again that the system is failing to deliver for them. The challenges we face are increasingly global, whether the development of AI, the threats posed by climate change, growing inequality, increased migration. We need a functioning global order underpinned by a strong commitment to the rule of law to even begin to tackle them. At home too, we cannot afford to be complacent about the extent to which values that we once took for granted have been undermined. A near decade of crisis and political instability has at times stretched the fabric of our constitution to its limit. Now, I don't wish to make a party political speech tonight. Indeed, I am determined to make the promotion of the rule of law a project we can all sign up to, irrespective of political allegiance. But nevertheless, it cannot go unsaid that as a lawyer and a citizen concerned with our constitutional framework, I watched aghast from the sidelines a moment I never thought conceivable in this country, when a Secretary of State informed Parliament that sections of the Internal Market Bill were designed deliberately to breach international law, a departure from our tradition of respect for international law so grave it provoked a suite of resignations. I then watched, with a mixture of fury, disbelief, and frankly profound sadness, as the previous government introduced the Safety of Rwanda Act. Now, I will leave it to my political colleagues to make points about the workability and costs of that scheme. But what was, to my mind, even more significant were the constitutional heresies contained within it. The Act starts with the OTO's and therefore crass assertion of parliamentary sovereignty. It moves to the express disapplication of fundamental international law obligations, including those owed under the ECHR, the Refugee Convention, and even customary international law. It then ousted the role of courts in determining relevant facts, except where individual circumstances were an issue, indeed obliging them to accept as true facts that may well have been false. It felt not so much as though we had fallen through the looking glass, but rather dived headfirst into it. It is unsurprising, therefore, that on the international stage, the United Kingdom, once a proud leading player in the establishment of our global structures and institutions, has seen its rule of law leadership called into question. However, at a time when there is a desperate need for cooperation and solutions, we are increasingly confronted by the divisive and disruptive force of populism. Now, this isn't a new phenomenon, but in recent years we have grown accustomed to diagnosing its symptoms on both the right and the left. We face leaders who see politics as an exercise in division, who appeal to the will of the people as exclusively interpreted by them as the only truly legitimate source of constitutional authority. Their rhetoric conjures images of a conspiracy of elites, an enemy that is hard to define, but invariably including the people and independent institutions who exercise the kind of checks and balances on executive power that are the essence of a liberal democracy and the rule of law. Judges, lawyers, a free press, NGOs, Parliament, the Academy, an impartial and objective civil service. Populists work to diminish their legitimacy at worst. Work to diminish their legitimacy, or worse, actively remove them from the scene altogether. And allied to this, we have also seen how populism, in its most pernicious form, works to demonize other groups, usually minorities, to discredit the legal frameworks and institutions that guarantee their rights, and dismantle, often through calculated misinformation, the political consensus that underpins it. Times of crisis and challenge are fertile ground for this type of politics. And they can create a receptive audience for the populist argument that the rule of law is somehow in tension with democratic values. And it's this dynamic that I want to address in tonight's speech. I want to argue that this is precisely the time for us to reaffirm that the rule of law, domestically and internationally, is the necessary precursor to those democratic values, providing the foundations for political and economic flourishing. And I also want to be clear that by the rule of law, I don't just mean rule by law, a purely procedural and formal conception that populists and authoritarians themselves so often use as a cloak for legitimacy. One of Lord Bingham's great contributions was to promote a more substantive conception of the rule of law, including the idea that the law must afford adequate protection of fundamental human rights. And I too believe that human rights, both at the level of principle and in practice through how they are enforced, are an essential element of the rule of law and a stable democratic culture. As well as recognising and protecting the dignity of all, they guarantee the essential rights and freedoms that underpin our system. So far from being at odds with democracy, as some populists would have us believe, the rule of law is the bedrock on which it rests. For what good is democracy? Indeed, can democracy exist without the right to free and fair elections or freedom of speech, guaranteed in turn by right of access to the courts and an independent judiciary? And I'll go further. Democracy, in my view, is inextricably linked to the rule of law, properly understood. For what good is the rule of law without democracy, which confers essential legitimacy on the rules that govern the relationship between citizen and state? Lord Bingham's conception of the rule of law also recognises that international law is the rule of law writ large, and that states must comply with their international law obligations just as they must comply with domestic law. This too, in my view, is crucial. International law is not simply some kind of optional add-on, which states can pick or choose whether to comply with or not. It is central to ensuring our prosperity, and it is central to ensuring our security, ours and that of all global citizens. As I will develop shortly, our reputation as a country that can be trusted to comply with international law and robust adherence to the rule of law is essential to our ability to grow the economy. And maintaining our international reputation also enhances our ability to work with our partners to get things done in this time of global challenge. In short, it messages that they can trust us. Rather than isolating ourselves from our closest allies, it means we can strengthen cooperation on issues like migration, whether that's the anti-smuggling action plan, which the Home Secretary secured with the G7 earlier this month, or working closely with international law partners to target smuggling gangs. Compliance with the law enables trust with partners. And to shore up the rule of law against the forces of populism, we must also emphasise its importance as an idea that unites us rather than divides us. The work to rebuild a political consensus around these values is essential, but it will not be easy. It must be proactive, it must be cross-party, it must be internationalists, and it must also be sensitive to the legitimate reasons why some people have lost faith in the rule of law and its institutions. It's going to require patient, long-term thinking, hard work and consistent commitment to build the necessary coalitions and produce and implement detailed policy proposals. So, to meet these challenges, it's my view we need to take immediate steps to restore the United Kingdom's reputation as a rule of law leader, whilst at the same time also seeking to build and secure the rule of law's long-term resilience in the face of threats known, unknown, domestic and international. Restoration and resilience. And as I said earlier, I want to talk now about three themes that will guide the government in this project. My first theme is rebuilding the United Kingdom's international rule of law leadership. Historically, as perhaps all of us know, the United Kingdom has been a leader in developing and promoting international law and the institutions on which its effectiveness depends. British lawyers and politicians have been at the forefront of drafting and negotiating the most important treaties that underpin our international legal system and in building the institutional machinery that breathes life into those paper agreements. And the United Kingdom is determined to once again demonstrate that leadership, essential in today's highly connected but highly fragmented world, and sadly so absent in recent years. And that work starts by clearly and without question honouring our obligations under international law. Now, since taking office, this government has already taken steps to uphold those obligations and demonstrate our deep commitment to international law. We've reached agreement with Mauritius to settle a historic sovereignty claims over the Chagos archipelago in a manner that successfully marries our international law obligations with vital national security requirements. We have applied our IHL obligations by compliance with our arms licensing criteria, applying law, not politics. We have made plain our commitment to the cornerstone institutions, not least the ICJ and the ICC. And, lest there be any doubt, we will continue to abide by and unequivocally support the European Convention on Human Rights, including by complying with requests from the court for interim measures. Walking, or threatening to walk away from the Convention and the court, would be a total abdication of our international law responsibilities and send out precisely the wrong message at a time when the rule of law is under threat in so many places. But we will go further than simply meeting our obligations under the Convention and international law. My point is that the United Kingdom will once again seek to be a champion for international legal institutions, taking positive steps to promote their importance and rebuild the respect for them that populists have sought to destroy. As the Prime Minister has said, having discovered the Convention in a law library in Leeds some 40 years ago, the rights it sets out speak about the dignity of every human being and are a source of inspiration from which we can all draw strength and value. After the First World War, this country championed the establishment of the Permanent Court of International Judges. British judges sitting in that court and in many subsequent international courts and tribunals have delivered judgments that have brought clarity to all areas of international law. And so I am delighted that the UK National Group has announced its intention to nominate Professor Dapo Akende, who will be known to many in this room, as the UK's candidate for election to the ICJ in 2026. I can't think of a better representative of the UK's expertise in international law, and I am truly delighted to endorse Dapo's campaign. And it is also through international courts that we hope to finally see justice for Ukraine. I have dedicated my professional life to fighting for justice and accountability, and nowhere was the need for that more apparent than my recent visit to Ukraine, where I was profoundly struck to the core by the stories that I heard at Bucha's Cathedral, a scene of a mass atrocity, and at the bridge in Irpin. Despite the unimaginable suffering that the people of Ukraine have endured, they remain clear-eyed about the importance of the international rule of law and accountability. And I and the whole government remain steadfast in our support for Ukraine on the battlefield and in the courtroom, including support for the establishment of a special tribunal on the crime of aggression. But these systems and the promise offered by international law only work when we work in partnership with our friends and partners around the world. And we need to acknowledge that in many parts of the world, especially in the global south, the international rules-based order and human rights are often seen as imperial constructs, selectively invoked by Western governments as and when it suits their interests. So I believe it is incumbent upon us to first listen to those who feel unheard and understand their concerns and their perspective. And secondly, to demonstrate, not just with warm words, but with concrete actions, that international law can deliver real benefits to all of us. And those actions must be consistent, and they must reveal that we will always hold ourselves to the highest standards. We will advocate for reform of the Security Council to ensure that those with seats at the top table truly represent the global community. This means permanent representation from Africa, from Brazil, from India, and Germany. And our approach to international development will reveal that we have learnt lessons from history, that to be sustainable, the rule of law cannot be imposed on countries by former colonial rulers, but rather must be grown collegiately and organically from within, working closely with local communities and institutions. We will also be unwavering in our commitment to tackle climate change, where we know that many of the worst effects are felt by those who have made the smallest contributions to this existential threat. So theme 1 is a reset on international law and our commitment to the international legal order. My second theme is closer to home. A crucial part of restoring the rule of law and building resilience in the face of future threats involves thinking about the respective roles of our own institutions in upholding fundamental values. And this must start by recognising that upholding the rule of law cannot just be left to courts. All branches of our constitution must see the rule of law in its fullest sense as a guiding force for their own actions. And speaking as a new member of 2 of these branches, I hope my colleagues in this room won't mind if I offer some initial reflections on the role of Parliament in this regard, both in terms of its own functions and the government's relationship to it. Parliamentary sovereignty is, of course, one of the fundamental features of our constitution, and the ultimate legal authority of Parliament to make or unmake laws is crystal clear. However, viewing the rule of law through this distorting lens of ultimate decision-making authority alone risks mistaking it for a purely formal and thin conception of rule by law. As lawyers know, Parliament's authority in our constitution is legal authority, an authority that requires Parliament maintains in its legislation the ideals of the rule of law, of government under law, one of the contributions to the modern world of which we, the UK, are justly proud. And as I, following Lord Bingham, have explained, those ideals are much thicker and more substantive than the thin gruel of formal conception of rule by law. We have seen in recent years where that disregard for our constitutional rule of law heritage can lead. It is crucial that all institutional actors understand their role in a government under law. When a government invites Parliament to breach international law or to oust the jurisdiction of the courts, it not only undermines the rule of law, but also the mutual respect that historically has been one of the greatest strengths of our constitution. It risks pitting one institution against the other in ways that damage our reputation, both inside and outside our borders, as a law-abiding nation. We must also domestically work to counter the false choice offered by some between parliamentary democracy on the one hand and fundamental rights on the other. For almost a quarter of a century now, the Human Rights Act has shown how it is possible, with imagination, to provide a legal framework for the protection of fundamental rights which can coexist with parliamentary sovereignty. Indeed, the Act, as we know, specifically preserves Parliament's ultimate decision-making authority through its regime of non-binding declarations of incompatibility, defences and Section 19(1) statements. And the enforcement of the Act, otherwise by the courts, far from being at odds with democracy, is its vindication, because it was our democratically elected Parliament that legislated for the human rights. And it was Parliament that provided the mechanisms by which individual rights should be given meaningful effect in domestic law. So it is a testament to the framers of the Act that no Parliament elected since 1998 has chosen or succeeded in fundamentally altering that position. It's also right to reflect with humility as a parliamentarian how Parliament itself can protect and enhance rule of law values. Now, it does this in part through scrutiny of legislation, most notably through the expertise of my colleagues in both houses, but also through the select committee system. And it is incumbent on any government to ensure that those committees are able to do their job effectively. So I welcome the contribution that committees such as the Lords Constitution Committee, the Delegated Powers Committee and the Joint Committee on Human Rights make to the debates on human rights and the rule of law. And I look forward to working with them and all the select committees in Parliament. But there are some aspects of the government's relationship with Parliament that require more careful examination. Most pressingly, in my view, there is a real need to consider the balance between primary and secondary legislation, which in recent years has weighed too heavily in favour of delegated powers. The twin challenges of Brexit and COVID pandemic had the effect of concentrating immense power in the hands of the executive through the conferral and exercise of broad delegated powers, including so-called Henry VIII powers. Now, some of this can be explained by the exceptional character and unique demands of both events. However, it would be a mistake to view it as an aberration. As the Delegated Powers and Regulatory Reform Committee have noted, Brexit and COVID did not mark the beginning of the shift in the balance between Parliament and the executive, so much as the acceleration and intensification of an existing trend. Now, as technical as these issues may sound, they raise profound questions about how we are governed. I said earlier that I see democracy as inextricably related to the rule of law. In our system of parliamentary democracy, consent to be governed is expressed through the delegation every 4 or 5 years of powers by the governed to Parliament. It's the importance of this model of consent that explains in very large measure why I have been so concerned upon entering government to improve the standards we adhere to when we make policy and law, and specifically to ensure that the processes we adopt support the rule of law. Secondary legislation has, of course, an indispensable role to play in modern regulated society. I'm not suggesting for a moment that the government should not take or exercise delegated powers. However, excessive reliance on delegated powers, Henry VIII clauses or skeleton legislation, upsets the proper balance between Parliament and the executive. This not only strikes at the rule of law values I've already outlined, but also, in my view, cardinal principles about accessibility and legal certainty. So in my view, this new government is afforded an opportunity, and must take, to a reset in the way that we think about those issues. This means, in particular, a much sharper focus on whether taking delegated powers is justified in a given case, and a more careful consideration of appropriate safeguards. I turn to my third theme, and I want to talk about culture and how we promote a rule of law culture that builds public trust in the rule of law and its institutions. A vital task if the rule of law is to be made resilient enough to withstand the threats I have described in this age of populism and this time of cynicism. So we begin, as I have said, from a difficult place. But too often, the starting point for debate is that law is part of the problem. At best, an abstraction, it is said, that is disconnected from the realities of people's lives. At worst, held up by populists as a force that is somehow illegitimate. Now, all of us who care about this subject, and particularly those of us in government, need to work hard to counter these attitudes and to foster a better understanding of the rightful place of law in a liberal democratic society. For the government, it means leading by example. Now, I hope you take some, but limited comfort in the fact that the importance of the rule of law and the constitutional balance is embedded in my DNA as attorney. It's also embedded of that of the Prime Minister, who not only rose to the top ranks of the bar, but served his country as DPP. And it is also a principle that is deeply cherished and jealously protected by the Lord Chancellor, who has overarching constitutional authority for the protection of the rule of law, not least the protection of the independence of the judiciary. And anyone who knows the Lord Chancellor and her determination to champion the rule of law will know that there will never be, under her watch, a repeat of failures of some of her predecessors to defend attacks on the judiciary. That's not going to happen under this Lord Chancellor's watch. Of course, rightly, you are going to judge us by what we do, not by what we say. And we will demonstrate our commitment to the rule of law in real and practical ways. I mean, to give you just one example, in the coming weeks, I am going to issue amended guidance for assessing legal risk across government that will seek to raise the standards for calibrating legality that the thousands of brilliant lawyers working every day in every part of government activity apply to deliver for this country. And in so issuing that guidance, I'm going to want those lawyers to feel empowered to give their full and frank advice to me and others in government and to stand up for the rule of law. But we should be under no illusion. The challenge to rebuild a broad consensus around the rule of law cannot be left to politicians alone. It is a project that can only succeed if it's taken up by all of us. Politicians, judges, lawyers, civil society, citizens. And we need to recognise that populists have stolen a march. It's nearly always easier, often in the form of three catchy words, to deride and denigrate than it is to promote complex principles. But we cannot stand idly by as rule of law principles and the human rights idea are undermined, sometimes without challenge, on our television screens, in the pages of newspapers, and most effectively but invidiously of all, on social media. The challenge for us all is to get out and explain the importance of the principles that we hold so dear. We have a fantastic story to tell, and tell it we must. We need to explain that the rule of law is not the preserve of arid constitutional theory. We need to explain how it provides stable and predictable environments in which people can plan their lives, do business, get ahead, in which businesses can invest, the economy can grow, people can resolve their disputes fairly and peacefully, and express and enjoy their basic rights and freedoms. This is the story we must tell. We must illustrate how systems that do not hold to these values can be arbitrary and capricious, and how backsliding from rule of law values, once it begins, can take an unpredictable course. So the story we must tell is how the rule of law matters, how it matters in real terms, how it matters for growth, for jobs and people's livelihoods, how it impacts upon the pound in their pocket and on the type of future that their children deserve to enjoy. Governments that undermine or take a pick-and-mix approach to these values disincentivize investment. They are anti-growth. Today, we are hosting the Investment Summit with a clear message that Britain is open for business. Now, this country has many commercial advantages, but one of our greatest is the trust that businesses can have in our courts and the confidence they can have in a stable and transparent business environment underpinned by a strong rule of law. Education has a crucial role to play. We've got to take these messages to our schools and wider communities. And so I commend the work of civil society groups and charities such as Young Citizens, the Citizenship Foundation, and of course the Bingham Centre itself, who work with schools to promote a better understanding of the law and its importance in society. I believe it's right to think about whether even more can be done to strengthen the role of citizenship education as a means of promoting a better understanding of our Constitution and the importance of the rule of law. We've got to talk about these issues in a way that resonates with the public. We've got to talk about these issues in language that everyone understands. Because I believe that most people would instinctively recognise rule of law principles as values that are part of the very fabric of our society. Fair play, justice, rules that apply equally to all, not one rule for them and another for the rest of us. And where disputes do arise, whether in business, an employee or a neighbour, an independent court system which provides the means for just resolution. And in the public realm, law as the great leveller that holds power to account, ensures individual rights are respected. We need to explain how those rights, human rights, are our rights. They belong to us all. And so it is that we must proudly own the story of the European Convention on Human Rights, not least by telling that story with pride. We expose the wanton superficiality of many of its critics. We must explain how the values of the Convention are not foreign to us. They are universal. They are closely connected rights that are found deeply embedded in the heart of our own British legal tradition. Echoes of habeas corpus, Magna Carta and the Bill of Rights can all be located in Articles 5 and 6. This country banned torture long before our continental cousins, never mind the creation of Article 3. So it's no coincidence that it was British lawyers, most notably the conservative David Maxwell Fyfe, who helped frame the European Convention after the Second World War, drawing, of course, on inspiration from the Universal Declaration of Human Rights, but also centuries of our own legal values. So it is simply legally fatuous and historically ignorant of armchair critics of the convention to declare that its supporters somehow seek to undermine our traditions or should be dismissed as some form of naive snowflakes. To the contrary, the convention was drafted by men and women who had witnessed the very worst that humans can do to each other. Their views were not forged in the comfort of a Tufton Street seminar, but in the trenches and in the battlegrounds and in the prisoner of war camps and in the historic prosecutions of Nazi war criminals at Nuremberg. The drafting and adoption of the convention took place not in a time of overindulgence, but when societies were rebuilding from the rubble, and indeed this country was still under rationing. They were hard-nosed men and women from a generation who had seen conflict and vowed never again. The structures they helped to create, the values that underpin them, have served as a bulwark against totalitarianism and a foundation for European peace. And they remain the best hope of protecting us from the threats we face today. For too long, populists have been able to frame the debate on human rights too narrowly, by reference which, important as they are, often feel disconnected from the everyday. So as I have said, it is our task to change this, not only busting myths, but by showing how human rights positively touch so many aspects of wider society. So too must be work to combat disinformation and misinformation about law and lawyers, the disgraceful scenes of violent disorder over the summer, including threats against immigration, law firms and advice centres, showed only too vividly that what is said online can have dangerous consequences in the real world. But the response to the riots also showed something more hopeful. People took to the streets, not only to clean up and repair the damage, but to stand together against the forces of reaction and division. And it is that spirit of decency and fairness that we must harness in the cause of supporting the rule of law. When I went to Liverpool in the aftermath of the riots, I visited the library that had been burnt down, and I met a remarkable group of children ranging from 6 to 16. And they described how on the night before the riots, they had been cowering under beds and in cupboards. But the next morning, ages 6 upwards, had come in to the library to volunteer to help rebuild. And I talked with them about the notion of justice, and I gave them some books on the theme of justice and accountability. One of them was Helena's book, and talked to them about how law and justice work together and what the rule of law means to them. And we discussed the meaning and significance of an inscription that my office had placed inside each book, which took the words of Dr. Martin Luther King, that although the arc of humanity is long, it bends towards justice. Restoration and resilience will be the watchwords that will guide our defence of the rule of law in the face of populism. It is by renewing our commitment to the rule of law values as a government and as a nation, at home and abroad, and patiently rebuilding the political consensus underpinning that commitment, that we will ensure that the rule of law is safe for future generations, so we may continue to work together towards achieving the Bingham Society's vision of a world in which every society is governed by the rule of law in the interests of good government, peace at home, and in the world at large. Thank you very much.